with a satire and to conclude by underscoring the enormity of the Lord upon your shoulders on the issue before you. In the trial of the goat, the antelope, and the elephant asks the antelope, "Why are you running?" The antelope says, "I'm running because they are arresting goats." "But you're not a goat." The antelope tells the elephant, "It may take 20 years in a Kenyan court to prove that I'm not a goat." The elephant says, "Then if that be the case, let me also take flight." The question that I seek to answer is this: whether the basic structure doctrine is applicable in Kenya. If so, the extent of its application, whether the basic structure of the Constitution can only be altered, and I underline the word altered, through the primary constituent power, and what constitutes the primary constituent power. Let's start from the basics. The Constitution is the social contract that governs the relationship between the people and the governors. That dichotomy must, of essence, be clear in any constitutional democracy. The Constitution is susceptible to two things. One is alteration, and two is amendment. The definition of those two fundamental words is pivotal to the answer to this question. And I will start with the basic English definition before we go to the legal definition. Chambers' English Dictionary, which I've used for the last 25 years, defines alter as follows: to make different, to modify, to become different. It proceeds to define amendment as to free from fault or error, to correct, to improve, to alter in detail with a view to improvement. Perceive the presence of the word alter in the definition of amendment, and it appears to alter in detail. Here follows the legal definition of those two words. Black's Law Dictionary defines alter as follows: an act done to an instrument after its execution, whereby its meaning or language is changed. Amendment is defined thus: to make right, to correct, or rectify. In its judgment, the High Court determined what the basic structure is. And it is said that the basic structure entails the essential features, the core of a constitution. I purpose to hazard a definition of my own. It is the distinctive feature of a particular constitution. Now, remembering the definition of the word alter and amendment, what is the basic structure in our submission is that which can only be altered. And what is left for amendment is not the basic structure. An argument was made that this doctrine is emergent. Is it so? It is my humble submission that the doctrine is not emergent. John Locke, in his book, The Two Treatises of Law, defined what a basic structure is. Charles Montesquieu also defined what a basic structure is. Permit me just to refer to their definitions. You will find this in volume 1 of our list and bundle of authorities. Now, at page 241, a trichotomy of the systems of government is made. This is by John Locke. 1, there is a perfect democracy where the people elect those to make laws for them. 2, there is an oligarchy in which a few select men constitute themselves the leaders. Lastly, there is a man, unfortunately those days they were just writing in the male gender, who constitutes himself the monarch with the succession to his son. Let us see what Montesquieu says about the structure. You'll find this at page 318 of volume 1. And it is subtitled, Difference Between the Natural and Principle of Government. He says this: there is this difference between the nature and principle of government. Nature and principle of government. That the former is that by which it is constituted, and the latter that by which it is made to act. One is its particular structure, and the other, the human persons which set it in motion. Still on altar and amendments, because these are the identifying two elements of the basic structure, can we have a look at the path that the Kenyan people have traveled since independence? We will start with the Independence Constitution. I will call it the 1963 Constitution. The marginal note to section 20 provided as follows: alteration of this order. If you were to look at section 71 of that particular 1963 Constitution, it says, Parliament may alter any of the provisions of this Constitution, save for section 156. What did section 156 of the 1963 Constitution provide? It provided for devolution. It provided for an advisory commission, and it also provided for finances to be allocated towards devolution. This was the entrenched clause in the 1963 Constitution. It could not be altered. Sorry, it could not be amended. It could only be altered. Let us look at the 1969 Constitution. The mode of that change is found in section 47. Subject to this section, Parliament may alter this Constitution. And then subsection 5b, alteration is defined. References to the alteration of this Constitution are reference to the amendment, modification, or reenactment with or without amendment or modification of any provisions of this Constitution, the suspension or repeal. Yes, it may appear as if there is a conundrum, but as you consider that conundrum, that is the perception of what the people of Kenya have over this, which is otherwise a simplistic issue. Now, that dichotomy has been expounded further, and I will refer you to what is written by Professor Ben Nweze on the same issue. Ben Nubweze, writing on the topic Presidentialism in Commonwealth Africa, the chapter on presidentialism and constituent power, looks at the history of several African constitutions. He proceeds to examine, in particular, the Kenyan Constitution. And at page 527 of volume 2 of our list and bundle of authorities, he arrives at a conclusion demarcating the strict power of amendment and the repeal power. And he concludes, and if you permit me to read at page 527, this alternative method, that is amendment, that was used initially in Kenya appears to be legally unimpeachable, since the power to alter the constitution was rather widely defined to include amendment, modification, etc. Then he proceeds. However, applied to the independence constitution, it may be doubted whether the spirit of the amending power contemplated the destruction through the superimposition of a republican presidential form of the system of government instituted by the constitution, namely monarchical parliamentary government. The so-called amendment, in fact, established a new constitution and as such should have been effected by the repeal of the existing independence constitution. If there was any clarity that was required in differentiating between those two, perhaps I may look at a recent work on this issue, and permit me to refer to the book by Professor Richard Albert, Constitutional Amendments, Making, Breaking, and Changing Constitutions. Richard Albert, again, creates the difference between amendment and dismemberment. If I may refer the court to page 76, all the way to page 78, and at page 79 thereafter, Richard Albert sets out 4 fundamental aspects of what is in actual fact a constitutional amendment. He says there are 4 fundamental features to a constitutional amendment, properly defined: its subject, authority, scope, and purpose. He proceeds to define what dismemberment is at page 84. He says, dismemberment is incompatible with the existing framework of the Constitution because it seeks to achieve a conflicting purpose. And note that that conflicting purpose will be bad. A conflicting purpose may still be desired and attained through dismemberment. But what must not be lost is the manner in which those 2 elements, amendment and dismemberment, relate to the Constitution. Is the basic structure doctrine applicable in Kenya? The answer is yes. You've seen it from the writings of Professor Nubweze in the book I've just referred you to. In fact, Professor Nubweze refers to the Constitution in the following terms. Still on that book at volume 2, page 500, he says, a constitution is supposed to be a permanent charter which is to endure for ages to come and not to be lightly altered to meet the temporary expediency of party politics. Temporary expediency of party politics. Now, Proceeding from that premise, the Kenyan courts have examined the applicability of this principle, and they did so 15 years ago. Sorry, I think it's actually 18 years ago. And this is the case of Njoya and others versus the Attorney General. And remembering what Professor Nobweze has written about the Kenyan Constitution, we look at page 688 of volume 2. This is what Justice Aaron Ringera, as he then was, said about those amendments we have just referred to in Nobweze. The effect of those amendments was to substantially alter the Constitution. Some of them could not be described as anything other than an alteration of the basic features of the Constitution. And they all passed without challenge in court. I will repeat the same thing I said here before the Court of Appeal. This time, they have been challenged. A determination has been made by the High Court. Another determination has been made by the Court of Appeal. My lords and my lady, the Court of Appeal dealt with this issue in very elaborate terms. If you look at the decision of Justice Musinga, President of the Court of Appeal, he picked the essential features as the identifying character of the basic Constitution. Justice Okwengu located the pillars as the basic structure. Justice Nambuye said it is the Constitution itself and what it contains. Justice Kiage said, in his words, the basic structure reminds him of a house. Now, you're being asked to reverse the decision of the High Court, the decision of the High Court and of the Court of Appeal by extension. Permit me, before I close that issue, to underscore the jurisdiction of this court. The jurisdiction of this court is set out under Article 163 of the Constitution, and sub-Article 7 is expressed. It says, all courts other than the Supreme Court are bound by the decisions of the Superior Court. What does this mean? It means all those decisions can be put aside, but you, the Supreme Court, ought to make a decision. How then will you make a decision? 10 years ago, when I argued the case alongside retired Judge of the Court of Appeal, Richard Otieno Kwach, he told me a judge is first an advocate and second a judge. A judge is presumed to know the law. Assuming that you are to put aside all decisions that appear conflicting, then you must determine this issue first-hand based upon the law, because you're not a council of village elders. You're not the Sanhedrin to decide ecclesiastical matters. You are in the same position as the Supreme Court of Colombia. You should not be held siege, as was the case in 1985, when Pablo Escobar, whose attempts to become president of Colombia had failed, and he had been removed from parliament, decided to take on the court. What is the extent of the application of the basic structure to the Kenyan Constitution? Let us look at what the High Court and the Court of Appeal said. They located the basic structure in the chapters of the Constitution. They went with specificity to underscore the preamble, the republic, the executive, the judiciary, the commissions, amongst others. Let me just explain some of them. Let us look at the executive. What is the nature of the executive in Kenya? It is pure presidential. What did the BBI bill seek to do? It sought to create a hybrid presidential and parliamentary system where we'll have a president and a prime minister. That was a fundamental change. It amounted to an alteration of the system of government which the people of Kenya had said will govern them. What about the legislature? The system of the legislature in Kenya underscores separation, where elected members of the National Assembly and the Senate cannot be part of the executive through the cabinet. A well thought out entrenchment. What did the BBI bill seek to do? It sought to fuse the executive and the legislature by ensuring that the president has the power to appoint cabinet ministers from the legislature. Again, a fundamental departure from that which the people of Kenya had agreed upon. What about the judiciary? The judiciary is supposed to be independent and accountable. The process towards this entrenchment was a long process. In this BBI bill, an ombudsman, who I call the prefect of the executive, sought to be put within the judiciary. Again, a fundamental departure. To that extent, it is my humble submission that I have indicated the extent of the application of the basic structure and to what end that basic structure was to be interfered with through the BBI bill. Now, whether the basic structure of the Constitution can only be altered through the primary constituent power. The word alter was specifically used by the High Court and the Court of Appeal. All the judges of the Court of Appeal created a clear distinction between amendment and alteration. I believe, therefore, there is merit in the framing of issue number 1 by putting the word alter, and in issue number 2 by putting the word amendment. It is my answer that the basic structure can only be altered through the primary constituent power. This therefore begs the question, what is the primary constituent power? Where did it emanate from? Is it textualized? The argument put forth by the appellant is that this constituent power is non-existent. It's not textualized. And that if the people of Kenya wanted it to be part of the Constitution, nothing would have been easier than for them to say so. Now, constituent power traces its origin to antiquity in constitutional jurisprudence. You will find it in the written works of John Locke. You will find it in the written works of Charles Montesquieu. But permit me to pick what a recent writer has said about constituent power. A book written by Professor Justice Ernest Wolfgang, titled Constitutional and Political Theory, traces the origin of the constituent power. At page 169, the problem and concept of the constituent power, he says, the constituent power is the basic legal order of the polity, the basic legal order of the polity. But whence does the legal constitution derive this special validity and agency? After all, it does not exist simply by virtue of itself as an irreducible primordial phenomenon. Irreducible primordial phenomenon. He proceeds, it derives its claim to validity and its special legal quality, if not from the mere fact of its creation, from a preceding entity that presents itself as a special power or authority. Ever since the French Revolution, that entity as the constitution-making power is referred to pouvoir constituant. And then a further definition is given at page 172. And this is what Justice Professor Wolfgang says. It was developed first in 1788. 1788. So when somebody tells you it's emergent, it was picked from nowhere. That is what Justice Kiage says. Those are alternative facts and misrepresentations of the law. Now, let's look at the definition given by Professor Nubweze on what this constituent power is. Writing on presidentialism and constituent power, this is what Nubweze says at page 496 of volume 2. And it's fundamental because of issue number 2. Recalling again that the president under the presidential system in Commonwealth Africa is the organ that coordinates and therefore dominates the executive and the legislative process of government, a question is asked. A question is asked. Does the president also assume constituent power? And then he proceeds to say, the nature and importance of the constituent power need to be emphasized. It is a power to constitute a frame of government for a community, and a constitution is the means by which this is done. It is a primordial power, the ultimate mark of a people's sovereignty. Professor Nubweze elaborates the manner in which that power is exercised, and you'll find this at page 511 of the same volume. He sets out 4 sequential steps. 1, the framing of proposals for a constitution. 2, popular consultation. 3, formalized discussion. And 4, plebiscite, aka referendum. What my colleagues have told you is that under Kenya's constitutional jurisprudence, the only avenue for people's participation is through the referendum. No, that cannot be the case. The 4 sequential steps stressed by the court emanate from this elaborate pronouncement, this clear writing on what has to be done. If you proceed to read that particular chapter, that elaboration is emphasized as the dichotomy between the actual and strict power of amendment and the repeal power. Now, permit me also to look at what Professor Yaniv Rosnai has said about constituent power. Yaniv Rosnai, in his book, Unconstitutional Constitutional Amendments, The Limits of Amendment Powers, writes as follows, commencing from page 105. He says, constituent power is the power to establish the constitutional order of the nation. It is the generative principle of modern constitutional arrangements. And then he proceeds to define further what the constituent power does. And he proceeds to say, it has the framing power, the establishing power. You'll find this at page 120 of that book. Now, we have seen what the basic structure is. We have seen the extent of its application. We have seen the manner of alteration of the basic structure. And it is for that reason that we must answer this question. Because my learned friend James Orengo said, what is this doctrine? Is it like a stone that we just have to kick it and see it? No, it is not as nebulous as presented. Because if it was so, then there will be a demand upon the court to locate from the Constitution independence of the judiciary. separation of powers. It is for that reason, therefore, that these concepts are called basic concepts. It is like the ABCD, it's like the ma, me, mi, mo, mu. If these concepts cannot be appreciated in the most simplistic words, then there can only be two conclusions. One, a deliberate intention to mislead the court on the application. Or two, failure of understanding of basic concepts. As to which of those two this relates, I will leave it to the court. I will allocate 8 minutes to issue number 2 and leave the rest to my colleague Esther Ngawa. Whether the President can initiate changes, amendments to the Constitution, and whether a constitutional amendment can only be initiated by Parliament through a parliamentary initiative under Article 256 of the Constitution, or through a popular initiative under Article 257 of the Constitution. Let me answer that question with a lot of simplicity, and the simplicity is derived from the nature of the Republic under the Constitution. Now, under Article 1, the sovereignty of the people has a trichotomy of Parliament, which is the legislative arm of government. Then we have the national executive, which is the executive arm of government, and we proceed to the judiciary. What is key to us are two, and we'll find this in Article 94. What is the role of Parliament? The role of Parliament is set out under Article 94 thus: the legislative authority of the Republic is derived from the people and at the national level is vested and exercised by Parliament. You proceed to item 3. Parliaments may consider and pass amendments to this Constitution. Pass amendments to this Constitution, not alter. And for this purpose, I must emphasize, the word alter appeared in the 1963 Constitution. It appeared in the 1969 Constitution. It has disappeared in the 2010 Constitution. Now, compare that with the power given to the President under Article 131. The President, B, exercises the executive authority of the Republic to respect, uphold, and safeguard the Constitution. Nowhere in the Constitution will you find any indication of the power to initiate amendments on the part of the President. It's nowhere. And if we may go back to Professor Nobweze, he has made it quite clear that the moment the constituent power has been exercised and the Constitution has been birthed, the individuals in office must exercise the power given to them under that Constitution. Should they seek to alter, they must go back to the people, and they must do that through the 4 sequential steps. The President cannot be President and at the same time be the people. He can't. And if any clarity is required on that issue, we go back to what Justice Professor Wolfgang said, and you'll find this at page 172 of his book. Its goal, the goal of the constituent power, was to counter the king's sovereign powers grounded in law and tradition, and the institutions of the monarch with the original and unbounded political decision-making power of the nation as the force that brings forth the Constitution. Let me simplify this thing. What you're being asked to do by answering this question in the negative is this: to constitute Kenya into a monarchy, or to constitute Kenya into an oligarchy. Kenya is a democracy. It cannot be done. Let me close that argument with an extract from Professor Nobweze, who demystifies that which my colleagues here want to complicate. Nobweze has dedicated an entire chapter on the power of the president and the limitations to that power. If I may take you back to volume 2, and this one is titled "The Office of the President." And the operative extract will be found at page 482. And this is very important, 482. Aside from his legal immunity from suit and from insult, you cannot insult the president. If you think you are equal to the president, just insult him. You will see what will happen to you. Equality is hardly apt to describe the social relations of an African president. Inequality is a necessary feature of the African society. And then he closes by this depiction, which you'll find at page 483. Splendor is indeed part of the social preeminence of African presidents. You'll not find them riding a bicycle like the French president, Macron. You'll not find them eating a burger like the American president, Obama. No. Personifying the state, writes Arthur Lewis, they dress themselves in uniforms, build themselves palaces, bring all traffic to a standstill when they drive, hold fancy parades, and generally demand to be treated like Egyptian pharaohs. Can I bring the traffic in Nairobi to a standstill? Can I build a palace for myself? Can I demand to be treated like an Egyptian pharaoh? No. And with that, a conclusion must be made. If the president is immune, if the president is supposed to protect the Constitution, the president has no role either in the popular initiative or in the parliamentary initiative by way of initiation. He can't. It must be left to the people through the constituent power, or it must be given to the people's representative, the constituted power, which is Parliament. Hence, the clarity in those two initiation processes. If there is anything that I have not said, I will answer it in the questions, should any be asked. There is something that I must speak about. Veiled threats have been given to the court that you must not interfere with what the president has done, because the president gets information that is not available to you and I. The president knows who are the enemies of state. Look, if the president decides that Nelson Havi is the enemy of state, and I'm disappeared, I'm abducted, and these things happen daily, we can't question that? No. The president is not the king. The president of Kenya is not a pharaoh. The president is a servant of the people of Kenya. He exercises delegate executive power, and he must be brought to check if he veers off. And fundamental to that premise is this: the president cannot say from one side of his mouth that I'm an ordinary citizen entitled, just like Wangare, Omondi, and Wafula, to initiate a popular initiative towards constitutional amendment, and at the same time say, no, I'm immune from everything, including a transgression of the Constitution. Yesterday, Chief Justice Emeritus, responding to the comments on Twitter that there is maximum security at the Supreme Court, said this: Why can't this security be used towards the enforcement of court orders? My ladies and my lords, let me be frank to you. What is being prepared is synonymous to the 1985 palace siege of the Supreme Court in Bogota. That is how it started. If we can't get this, we must threaten you with this. You must not succumb to the threat, which is a veiled threat, that behold, here you are enjoying immunity as judges. Why are you not giving me similar immunity to do that which I must do? For the people of Kenya, exercise the judicial authority delegated to you without fear or favor. And here comes the dirge by Emperor Haile Selassie. You're better off dying standing than living kneeling. Do not be forced to kneel to the caprice and the oppression of those who find the Constitution as an inconvenience. I urge this court to dismiss the appeals by the first and second appellants, and to some extent consider that part of the third appellant's appeal that is in consonance with the general framework of our argument from the High Court to the Court of Appeal. I thank you most sincerely.